Welcome to the deep dive. We're here to take complex stuff and make it compelling. Today, we are diving into a really interesting case. It's from the world of public employment. We're looking at a dispute that kind of pits these long-standing contract promises against, well, state law. We've got our hands on quite a stack of documents here: an arbitration opinion, the award. It's full of legal arguments, contract clauses, all the tiny details of negotiation. Might sound a bit technical on the surface, but really it's about what happens when folks who work in public service retire. How are their benefits handled? That's the core.
Yeah, what's really fascinating, I think, is seeing how all these different things interact. You've got legislation, you've got the union contracts, the collective bargaining agreements, and even previous arbitration decisions. All of that shapes the financial reality for people who've spent, decades serving the public. So this deep dive, it should give you a really good look at how these agreements get interpreted and, maybe more importantly, how they actually get applied.
Right. So our mission today: understand this core conflict. It's between a county sheriff's office and its police unions, all about retiree health benefits. We'll look at the law that brought in mandatory contributions, the specific contract language that seemed to promise full coverage, and then, how an arbitrator finally decided who was right. Get ready, because there are some surprising twists, and you'll see how, the smallest details can really have a massive impact. Okay, let's unpack this then. At its heart, this is a dispute between the Passaic County Sheriff's Office and three police unions: PBA Locals 197, 197A, and 286. It all sort of boiled over between, late 2021 and early 2022.
That's right. And the basic disagreement, well, the county argued that retired members, they had to contribute towards their health insurance premiums. They pointed to New Jersey's Chapter 78, that's a public law from 2011, and also mentioned specific parts of the union contracts themselves. Their line was, the law says you pay, and the contracts don't override that.
But the PBAs, the unions, they saw it totally differently. They argued the county should be providing these health benefits to retirees with no contributions at all, or maybe at a much lower rate, like 1.5%, which was mentioned in the law too. And they based this on very specific language in their contracts. This wasn't just some abstract argument either. Actual grievances were filed for specific people, like Officer Christopher Diamond from PBA 197, Lieutenant William Panzardo, PBA 197A, and Deputy Sheriff's Officer Kenneth Macnish from PBA 286. And importantly, for everyone else in the same boat, these folks were seeing deductions they didn't expect.
Exactly. Real money. So to get this, you really need to look closely at the contracts and the laws involved. The county and the PBAs, they have these collective negotiations agreements, or CNAs. Basically, they're contracts setting out the terms of employment.
And this is where it gets really interesting, especially for the retirees, because all these different union contracts had key sentences, key provisions that seemed, pretty clear. For example, Article 14 Medical Benefits, Section 1E, it flat out said, upon retirement, the employer will continue to provide and pay for the above programs. And then there was another one, Article 14 Miscellaneous, Section 90, that said, the County of Passaic shall pay in full all medical and prescription premiums for all members who retire with 25 years of service or more. I mean, pay for and pay in full sounds pretty definitive, right?
It really does. Very clear language. However, the plot thickens because the agreements also had language talking about Chapter 78. There was a clause saying something like, all employees in the union shall be subject to the contributions outlined in Chapter 78 of Public Law 2011. And that clause became, a major point of contention. Was it just for active employees, or did it apply to retirees too? That was the million-dollar question.
Okay, so let's talk about Chapter 78 itself. This law came into effect in New Jersey June 28, 2011. It was a pretty big deal. It essentially mandated that public employees had to chip in for their health care premiums. The amount they paid depended on their income and the insurance plan they picked. And this wasn't immediate. It was phased in over 4 years, eventually hitting what they called Tier 4.
Right, Tier 4. And that meant active employees could end up paying a fair chunk of their premium costs, anywhere from 3% up to 35%, depending on salary. And connecting this to the bigger picture, the whole point of Chapter 78, as the state saw it, was to create these higher ongoing contributions. It wasn't meant to be temporary. The New Jersey Supreme Court even confirmed that later in a case called Ridgefield Park. And crucially, the law itself, NJSA 48.1023, specifically mentioned retirees. It said that retirees hired after a certain date in 2010 were subject to Chapter 78, but with a minimum contribution, often that 1.5% of their pension income.
Okay, so you've got this tension. Contracts saying pay in full for retirees with 25 years. State law, Chapter 78, saying contributions are required, even mentioning retirees specifically, albeit maybe at a lower rate for some. That seems like a recipe for disagreement. How did they try to resolve this when they clearly couldn't agree?
Well, exactly. So the unions and the county were negotiating their next contracts for the 2019-2023 period. They hit an impasse, couldn't agree. So the dispute went to something called compulsory interest arbitration.
And this is a really key difference for you, the listener, to understand. Interest arbitration is not about figuring out what an old contract means. It's where a neutral third party, an arbitrator, comes in and actually sets the terms for the new contract because the two sides just can't agree. Two different arbitrators were involved here, Ira Keir and Mark A. Winters, for the different PBA Locals.
Right. Now, during these interest arbitration hearings, neither side actually proposed getting rid of Chapter 78 contributions entirely, not even for active employees. That wasn't really on the table. But the county kitty did specifically propose removing that contract language we talked about, the parts that said the county would pay for and pay in full the premiums for retirees. That was Article 14.A5.
So the county tried to just delete that promise from the new contract?
Essentially, yes.
Okay, and how did they frame that?
Well, the county administrator, Matthew Jordan, he testified it was basically just a cleanup proposal. He argued that language wasn't really active anymore because Chapter 78 had changed things.
Sort of like saying, oh, that language is obsolete now, let's just tidy it up.
Kind of, yeah. But the unions pushed back. Hard. They argued, hold on, our members relied on this. This was part of the deal. Maybe they took lower wages over the years because they expected this benefit. They did not want that language removed.
So what did the interest arbitrators, Keir and Winters, decide about the county's proposal to remove the fully paid language?
This is crucial. Both of them summarily dismissed it, just threw it out. Their written awards basically said, any proposal we didn't specifically grant in this award is denied or dismissed. Often, they cited a lack of sufficient evidence or justification from the side proposing the change.
Wow. So the county failed to get that language removed in interest arbitration? It stayed in the contract?
It stayed in the contract. That attempt to clean it up failed. That set the stage for the next phase.
Which brings us to the grievance arbitration. Different arbitrator, Elizabeth McGoldrick. And a different job, right? Not setting new terms, but interpreting the contract as it was written, including that language the county failed to remove.
Exactly. Her core question was, did the county violate the agreements, the ones that still included the pay in full language for retirees, by continuing to deduct Chapter 78 Tier 4 contributions from retirees after those interest arbitration awards came down? The unions argued basically that the interest arbitration rulings meant the Chapter 78 requirement, as applied by the county, no longer held for these retirees. The contract language should now rule.
Okay, so how did Arbitrator McGoldrick analyze this? What was her reasoning?
She looked very carefully at everything. The PBAs really leaned on a fundamental principle of contract law called the plain meaning rule, which basically says if the words in a contract are clear and unambiguous, you have to enforce them just as they're written. Don't go looking for hidden meanings.
And the unions argued pay in full is about as plain as it gets.
Precisely. And the arbitrator seemed to agree with that logic. She specifically found a distinction in the contract structure. She determined that Article 4 teeth, paragraph F, the part mentioning Chapter 78 contributions, was intended to apply to active employees. But paragraphs 4T and 4T, the one saying provide and pay for and pay in full upon retirement with 25 years, those clearly applied to retirees.
So she separated the two groups based on the contract language itself?
Yes. She interpreted pay in full in its normal everyday sense. The county pays the whole premium for these eligible retirees.
Makes sense.
And critically, she also emphasized that even though Chapter 78 exists, her hands were tied, in a way, by the prior decisions of the interest arbitrators. Remember, they were the ones who considered and rejected the county's attempt to remove the fully paid language. The county had its chance then to argue. Chapter 78 made the language obsolete, and they failed to convince the interest arbitrators. So, Arbitrator McGoldrick reasoned the burden was on the county back then, and they didn't meet it. The language remained, and she had to enforce it.
Did the county have other arguments?
Oh, sure. They argued, for instance, that you can't enforce a contract provision if it directly conflicts with a state statute, citing some case law like Wolfersberger, a standard legal argument. They also brought up potential financial hardship. This will cost us too much.
Also pretty standard. How did the arbitrator respond to that?
She noted a lack of solid proof for the hardship claim. And interestingly, she pointed out that the county administrator himself, Mr. Jordan, had previously acknowledged the county actually had a budget surplus and had seen tax savings. So the hardship argument didn't seem to hold much water in her view.
Okay, so weighing all that, the plain language, the prior arbitration decisions, the lack of proof for hardship, what was the final verdict?
The final verdict from Arbitrator McGoldrick was clear. The county did violate the collective negotiations agreements. Her reasoning was that the interest arbitration awards essentially cemented a difference in treatment between active employees, subject to Chapter 78, and these eligible retirees. For the retirees, the failure to remove the fully paid language meant those original terms snapped back into place, overriding the county's continued Tier 4 deductions.
So the bottom line for the actual people involved, Officer Diamond, Lieutenant Panzardo, Officer Macnish, and everyone else like them.
Big news for them. The old county was ordered to reimburse them, pay them back for all the premium contributions that were deducted incorrectly. And this was retroactive, going back to the start date of those 2019-2023 contracts. So potentially a significant amount of money for each retiree.
Wow. And going forward?
Going forward, the county was ordered to stop making those Chapter 78 Tier 4 deductions from these eligible retirees. They basically have to provide the fully paid benefit, as the contract stated. Now, there might still be some statutory minimum contribution required by law, like that 1.5% for newer hires. The award acknowledges that possibility. But the higher Tier 4 deductions based on salary, those were out for this group. It really underscores a key point. While Chapter 78 set a baseline, the possibility to negotiate different terms for retiree contributions, especially after the law was fully phased in, still existed. And here, the way the interest arbitration played out meant the original, more generous language was effectively reaffirmed.
So wrapping this up, what does this deep dive really tell us? It seems like a clear example of how complex these things get. You have the contracts, the state laws, then layers of arbitration decisions interpreting both. It's like a complex web.
It really is. And it just hammers home the power of specific words in a contract. Pay in full meant something very concrete here. And it also shows the lasting impact of arbitration. A decision made in one context, the interest arbitration, had huge consequences down the line in the grievance arbitration.
Yeah.
What stood out most to you?
For me, it's that reminder that behind all the legal jargon and contract articles, there are real people planning their retirement based on promises made over decades of service. And seeing how one side try and do a cleanup of language, maybe thinking it was just procedural, could have led to significant financial stress for retirees if it hadn't been challenged and ultimately rejected by the arbitrators. The details truly matter.
They absolutely do. And I think this case leaves us with a bigger question, doesn't it? How do public bodies, how does society balance the need for fiscal responsibility, managing taxpayer money wisely, with the commitments made to public servants, especially commitments they relied on, maybe making other career or financial choices based on those promises?
It's a tough balancing act.
Definitely something to think about long after we finish here. We hope this deep dive gave you some valuable insights. Join us next time for another deep dive.